hand over to her shortly. Ms. Kamboka is an international development policy and advocacy expert. For the last 20 years, she has lent her expertise to position and promote policies and funding that advance development in the continent. Her vocation has enabled her to work closely with duty bearers in over 40 countries in sub-Saharan Africa, across Europe and parts of Asia. Ms. Kwamboka is a trustee and founding director of African Renaissance, a non-charitable trust that works to advance gender justice and health and equity across Africa. She holds a Master's of Arts degree in Political Science and International Relations and a Bachelor of Arts degree in Anthropology. Ms. Kwamboka is also a member of the technical working group convened by the SADC Parliamentary Forum to provide technical support on the development of the SADC public model law on public financial management. Madam Kwamboka, over to you. Thank you very much.
Thank you very much, Modise. A very good. Thank you very much, Modise. A very good morning to you and to to the distinguished guests in this meeting today. A very warm welcome to all the representatives of the financial intelligence units and anti-money laundering agencies of SADC member states. Today, we are going to have a dive into the public financial management model law that has been in development. And we are really looking forward to the conversations and discussions that we will engage on this morning. But before I start, I would like to really, have a session of, a brief introductions before we welcome our Secretary General of SADC Parliamentary Forum to give us the welcome address. But before that, and with your permission, Modise, kindly allow me to just have a quick check on the countries that are represented here today. And, it would be a delight to welcome and recognize all those who have made time to participate in this important conversation this morning. So I will go ahead and check alphabetically. Do we have representatives from Angola? Representatives, please, if you are representing Angola, please go ahead and introduce yourself. Anyone from Angola? Okay. Botswana? Representatives of Botswana? How about Comoros? DRC representatives? Eswatini? Representatives from Eswatini, please feel free to unmute your speaker. You can also put on your camera so that we have an opportunity to welcome you into this meeting this morning. Lesotho.
Good morning, everybody. I am Tenjire Murojele from the Financial Intelligence Unit of Lesotho. I'm supposed to also be joined by our director as well from the Financial Intelligence of Lesotho. I think he's been having a bit of a problem connecting, but he'll be trying. Thank you.
Okay, thank you. We continue to welcome those who are joining us, and just in case we have passed your country, feel free to raise your hand once we are done, and we'll be having an opportunity to warmly welcome you into the session. Madagascar, representative of Madagascar. Malawi. Representative of Malawi, yes, welcome. Take the floor, please. Oh, Madagascar. Okay, Madagascar.
Entrepreneur. Merci d'avoir donné ma parole. Entrepreneur Fanmisatsou, responsable des relations avec les institutions du SAMIFIN ou les services de renseignement financier au Madagascar. Bonjour.
Merci, merci beaucoup. Bienvenue. A very warm welcome to you, representative of Madagascar. Malawi. Malawi, the floor is yours. Malawi. Okay, when they join, we will welcome them to, to participate or to do the introduction. So now let us give an opportunity to Mozambique. Representative of Mozambique. Mozambique. Any representative from Mozambique, you're welcome to introduce yourself. Namibia. Namibia. Okay, over to Seychelles. Seychelles representative, please reintroduce yourself. South Africa.
Good morning. My name is Peter Alberts. I'm from the Financial Intelligence Center in South Africa. Our director, Advocate Kulisile Kanyile, is unfortunately in international engagements out of the country. So I'm representing the director of the Financial Intelligence Unit in South Africa. Thank you.
Thank you. Thank you very much. South Africa. Tanzania. Tanzania.
Yes,
Good morning.
Good morning.
I'm Julius Sulimo from Financial Intelligence Unit Tanzania. I'm representing the Commissioner of Financial Intelligence Unit, which is somewhat busy. And I've got also my colleague also from the Financial Intelligence Unit. His name is Ulimbakisi Makalobo. He's here with us also. Thank you.
Thank you very much, representatives from Tanzania. Zambia.
Good morning and greetings from Zambia. My name is Leah Tembo. I'm the Acting Director General. I'm represented this morning by Victor Zimba, our Director Finance, our Manager Finance, Nana, and our Manager Legal, Chileshe. Thank you.
Thank you very much, Team Zambia, Zimbabwe. Zimbabwe, you're welcome to take the floor. Okay, and a warm welcome to Mauritius. We had probably mentioned you earlier. Please feel welcome to take the floor and just introduce yourself as we are coming to a close for the introduction session. Mauritius.
Yes, good morning, everyone. I'm Atish Gopchan from Mauritius, and I'm the Acting Chief Legal Advisor of the Independent Commission Against Corruption. Thank you.
Thank you very much. I think, it is a great opportunity that you have all made time to be part of this consultative session that is led by the SADC Parliamentary Forum that are in the process of developing the public financial management model law for SADC countries. And it is at this juncture that I take the opportunity to welcome Ms. Boemo Sekoma, the Secretary General of the SADC Parliamentary Forum, to give us the welcome address. Ms. Boemo Sekoma, the floor is yours.
Bonjour, bon dia, good morning, dear colleagues, allow me to recognize our keynote speaker, Mr. Joseph Jagadam, the principal expert at the East and Southern Africa Anti-Money Laundering Group. Allow me to also recognize our distinguished representatives of financial intelligence units and anti-money laundering agencies from SADC member states. Let me also introduce and welcome Mr. Daniel Greenback, who is the legal drafter for the SADC model law on public financial management. Allow me to also recognize members of the technical working group on the model law for public financial management who are among us this morning, and also recognize and thank my sister, the facilitator of the meeting, Ms. Caroline Kwamboka, trustee and founding director of the African Renaissance. Allow me to also recognize SADC citizens who are following proceedings on various social media platforms, members of the Fourth Estate, the media, staff for the SADC Parliamentary Forum, and staff from national parliaments, distinguished participants. Dear colleagues and distinguished participants, it's with great honor that I welcome you all to this meeting of financial intelligence and anti-money laundering agencies, organized on the sidelines of the development of the SADC model law on public financial management. As you may be aware, the SADC Parliamentary Forum has held a series of stakeholder consultations so far. And this engagement is being conducted after consultations have been held with your line ministries, auditors general, attorney general offices, to name but a few. Distinguished participants, in view of managing expectations, I'd like to say at the outset that for every model law consultation, the forum usually consults a first cohort of stakeholders who are directly related to the model law at the policy level, such as ministries and public departments, state law offices, among others. And then a second cohort who are still linked to the model law, but other than from a policy perspective. Hence, we are aware that anti-corruption agencies fall in that second cohort. And I'd like to reassure you that all relevant policy consultations have already been made with your respective line ministries. Distinguished participants, your participation today will thus be fundamental on the practical aspects of the public financial model law. And we will be pleased to hear your practical views on how the legal provisions contained in the model law can be viably implemented with respect to corruption and anti-money laundering. I also want to highlight that the model law on public financial management does not deal in depth with aspects of money laundering and the financing of terrorism, that is AML or CFT, simply because this would have required a separate normative framework. In brief, the AML or CFT has linkages with public financial management. And today we will explore the linkages rather than address AML or FT in its entirety. Distinguished colleagues, why are we then engaging with yourselves as representatives of financial intelligence and anti-money laundering agencies? Today, we have within our midst anti-money laundering agencies across SADC member states. Thus, you are essentially lawyers and enforcement officers involved in the collection of information, investigation, or litigation in the realm of financial intelligence. Recently, there's been much media coverage of initiatives of the Financial Action Task Force and its dreaded list of high-risk jurisdictions, as well as the efforts made to have African countries removed from the European Union's grey list. I think I'm echoing the voice of all member countries that no Southern African nation would want to be blacklisted with regards to AML or CFT, with the overall objective being to keep the jurisdiction as clean and business-friendly as possible. Having said this, we fully appreciate that the Public Financial Model Law framework and the anti-money laundering and CFT are not the same thing. However, if both themes would be superimposed in a Venn diagram, we would have a common denominator. That is a shaded subset denoting an area where AML and CFT and public financial management overlap. Distinguished colleagues, we are thus of the view that you as representatives today are best placed to understand the inroads of anti-money laundering into the PFM framework. Indeed, anti-money laundering and CFT can also be relevant within the management of public finances, especially as the state in itself is tantamount to a multi-billion-dollar enterprise, and the flows of funds within the state are of a momentous amounts. It may not be uncommon in Africa to hear that public funds which have vanished from the state's coffers years back have been later found to be utilized to buy weapons or instruments to fight foreign wars. Needless to say that we all want this to end. Distinguished colleagues, enforcement officers and lawyers thus have first-hand experience of how corruption affects the African society and how mismanagement of public funds can amount to corruption. You are also aware that representatives of AML or CFT agencies are often called upon by parliamentary committees to give their views on whether transactions conducted by the executive are indeed corruptive or not. You are thus experts in your fields, whether it is public corruption, anti-money laundering, or the financing of terrorism. Dear colleagues, you are also best suited to identify the recovery measures to ensure that suspects or accused persons do not scoot free with laundering money or laundered money, besides paying for fines and other penalties of criminal nature. Indeed, you are also administering asset recovery legislation, which also agencies are assisted to make confiscation orders, recovery orders, to cite but a few. These are civil orders which are nonetheless important before and after criminal trials to secure laundered property. You thus have the practical knowledge on irregularities in the public financial management framework, which no other stakeholder will have. Today, colleagues, we kindly expect that you engage openly and frankly with the legal drafter, Dr. Greenberg, and the rapporteurs in view of discussing the linkages between AML and CFT and public financial management. Allow me to reiterate that the objective of today is not to delve into the PFM model law and look for extensive AML or CFT provisions, You may not find them, since these are two separate themes. But the objective is to consider the provisions on financial irregularities, appropriations, and cash flows, and determine if these provisions would work with your current AML or CFT framework. In particular, colleagues, I'll draw your attention to Section 48, which provides that Public Accounts Committee may make arrangements for disclosures to be made to it by individuals. And this would include representatives such as yourselves. It is well understood that different anti-money laundering agencies or CFT authorities across SADC have different powers and functions, and thus you may identify differently or with different areas of the model law to engage upon. Dear colleagues and distinguished participants, I wish to underscore that the model law, once adopted by the plenary assembly session of the forum in June, will continue to be work in progress. Indeed, there will be a need to domesticate the model law through usual routes or procedures at national level. In other words, through a consultation process that will be made under the auspices of the executive. You'll undoubtedly form part of the consultation, and hence the deliberations today will serve as a first acquaintance to the public financial management model law before it reaches to the domestic level after adoption. In addition, colleagues, as representatives of AML or CFT agencies, you are stakeholders who are of paramount importance in the monitoring of domestication, and the SADC Parliamentary Forum may later, through national parliaments, engage your organizations to furnish information through scorecards or shadow reports on which relevant provisions of the model law have been incorporated into domestic law. You will then be made to engage with the Regional Parliamentary Model Law Oversight Committee of the SADC Parliamentary Forum to address the issues of domestication from an AML or CFT standpoint. Before I end, I wish to state that the Public Financial Management Model Law is one of the teething issues of the SADC region, without which there will be no scope of sustained good governance. If a robust PFM framework is the driving wheel for good governance and a thriving democracy, then AML and CFT is the fuel that ignites the way forward. They are both sides of the same coin, and they depend on each other. In conclusion, dear colleagues, I thus wish to reiterate my gratitude for financial intelligence and AML CFT representatives today to continue keeping the SADC borders and the SADC region safe from financial irregularities that can upset the financial and economic landscape, and to continue protecting citizens selflessly. I wish to congratulate you for all the hard work, which sometimes becomes risky. On this hopeful note, I wish you all a pleasant session and fruitful deliberations. I thank you for your kind listening.
Thank you very much, Madam SG, for this very incisive and insightful remarks this morning. I really believe that the representatives that we are having today from the different financial intelligence units and anti-money laundering agencies have heard you. And before I invite our keynote address speaker to deliver his address, allow me, Madam SG and distinguished participants, to reiterate on a few things that Madam SG has highlighted. Key of them being that we have an opportunity today and moving forward as the model law is taking shape to explore the linkages there are between AML, CFT, public financial management, because indeed they do overlap, and the relevance of public financial management and the important role that it plays to foster inclusive growth, to really accelerate, if not strengthen, the post-pandemic resilience that we are facing as a continent and even as a sub-region. And to ensure that we are able to arrest joint vulnerabilities on the global frame actually requires your participation, and it requires your consultative status in this context, and by extension, your advice as we move forward to strengthen what is on the table as a public financial management model law for the SADC countries. And with that, I would like to pause and invite Mr. Joseph Jagadam, who is the principal expert at the East and Southern African anti-money laundering group, and allow me to make a brief introduction of Mr. Jagada, who has been with this secretariat, the East and Southern African Anti-Money Laundering Group Secretariat since October 2009. He deals with legal and law enforcement sectors, and in June 2018, he was appointed to the position of principal expert. He is responsible for all anti-money laundering and countering terrorist financing work, and this includes overseeing the portfolios of mutual evaluations, typologies, and the work of other staff. He has participated as an assessor in a number of AML CFT mutual evaluations that have been carried out within the sub-region of East and Southern Africa. And he has also been part of using the revised Financial Action Task Force standards. Back in the day, before this task, he worked as a prosecutor in financial crimes in the financial crimes section of the Director of Public Prosecutions Office in the Attorney General's office in Zimbabwe, rising to the Chief Law Officer and Deputy Director that is responsible for financial crimes, mutual legal assistance, and extradition. He has a master's in international law. Mr. Joseph Jagada, a warm welcome to you. The floor is yours to deliver the keynote address.
Right. Good morning to everyone. I'm really delighted to be part and parcel of this event, and I would like to, before I really start on my formal statement, to indicate that I'm only participating here today on behalf of the Executive Secretary of the SAMLAC Secretariat, who is not here today and is attending the FATF February plenary meetings. So this is why he could not join you, but he has delegated me this responsibility, which I am hopeful I'll be able to ably deliver. I will just highlight a few issues in my opening remarks, and which we see as probably some of the areas which have become a bit problematic in the implementation of MLCFT regimes in the SADC or a SAMLAG region. But now getting to my opening notes address, Secretary General of the SADC Parliamentary Forum and your staff, distinguished representatives of FIUs and law enforcement agencies from the SADC member states, dear participants, ladies and gentlemen, on behalf of the Executive Secretary of the SAMLAG Secretariat, allow me at the outset to express our appreciation to the SADC Parliamentary Forum for the kind invitation extended to us to take part at the consultative meeting on the model law on public finance management for SADC countries, majority of which are also members of the SAMLAG. As you know, corruption is one of the main offenses whose proceeds are laundered in different sectors of the economies of the SADC region, and financial intelligence units and the law enforcement agencies are an important element in fighting against money laundering, terrorist financing, and associated corrupt activities, as well as other predicate offenses. Remember, corruption also comes with a number of other offenses which are linked to it. And in most cases, which if they were not there, corruption would be very difficult to properly undertake and achieve the intended criminal activities. In this regard, consultative meetings for the FIUs and the law enforcement agencies based on a needs-oriented based approach is not only an important tool for combating money laundering and terrorist financing and other financial crimes, but also probably equally important for improving the working and living conditions of millions of people in Africa whose livelihood is being deprived of essential resources due to corruption, other financial crimes, and related money laundering. It cannot be emphasized enough how much retardation in development this has caused to the SAMLAG, including the SADC region in the past decade. Combined with other factors, financial crimes like corruption have also immensely contributed to illicit financial flows and accumulation of illegal wealth outside the SAMLAG and SADC regions. It is therefore a great privilege for me to share with this gathering the views and expectations of the SAMLAG on its efforts to combat money laundering and terrorist financing, and the contribution of its members and cooperating partners, including the SADC, to this endeavor. As requested by the SADC, I will put into perspective the FATF standards on the MLCFT CPF, which is combating proliferation financing. This is an element which has now been added to the FATF standards after they were revised in 2012. So it's also equally important and has to be equally addressed like we are addressing combating financing of terrorism and anti-money laundering. I was saying, as requested by the SADC, I'll put into perspective the FATF standards on MLCFT CPF, which all the SADC countries are a party to. I would like to really emphasize this, that all SADC member countries are a party to the FATF standards, and they have to be seen to be complying with the FATF requirements. And I should also hasten to say, under the FATF standards or FATF requirements, through our experiences with engaging with countries in the region, we have often heard statements such as, you know, why should we really be obliged to comply with standards which are set by a body which a body like FATF, which is really not important or is not at the level of the UN. I think, and also the other issues we have had are that why should these obligations apply to countries with weak economies like those in our region? And we have always tried to explain that if you look at the FATF standards closely, you realize that they are all derived from the UN conventions, and in particular, the UN Convention Against Corruption, the UN Convention Against Transnational Economic Crimes, and Counterterrorism Convention. So if you just go to the standards, particularly the recommendations which criminalize certain activities, they actually make reference to specific articles in these conventions, and also build up on the framework which is set out in these conventions to then be customized into what has now become known as the FATF standards. So, and currently there's also discussion in the FATF, particularly at this plenary meeting, as to whether FATF should not become an observer to the UN proceedings. So having said that, it is important for countries to note that in as much as they domesticate the UN convention requirements, the various conventions that I've mentioned, as long as they domesticate those conventions in their own domestic systems, they're actually complying and working hand in hand with the requirements of the FATF standards. So it's important, having said that, for countries to understand where these standards are coming from and why it is important for them to comply with the standards. Implementing the FATF standards and the relevant international instruments is both a vital and a very challenging task. It is comprehensive. These are the standards. In trying to cover, remember, with crimes, we can only try to limit how these crimes impact on the different society requirements. But in the end, it might be very difficult to completely suppress all the crimes. So in trying to implement these standards, they are covering mostly the preventive side of corruption and a wide range of other predicate offenses, and also the proceeds which can be trying to put measures in place, frameworks in place, and probably working regimes which ensures that any process generated from these offenses, in particular corruption for our jurisdictions, do not eventually find their way into other sectors where they are laundered. Particularly in most cases with our region is in the area of real estate. That's where you find most of these processes being laundered. And you also realize that, of course, with no prejudice intended, upcoming businesses like dealing in second-hand motor vehicles, we have also noticed that that has also become a very difficult, a very conducive sort of way in a laundering process of crime, mostly because there are cash transactions and there are no questions as to where the cash is coming from or who is buying the motor vehicle. So in as much as also the real estate sector is concerned. So these standards are actually intended to ensure that our countries, our governments, they have proper frameworks in place to fight some of these crimes, and at the same time ensuring that they do not interfere or retard any economic progress. So the standards also aim at ensuring that activities relating to financing of terrorism are controlled, and also financing of weapons of mass destruction are controlled. So in this way, they also achieve another important aspect of human rights, which is protection and treatment of victims, and also in the same process, encouraging, like this workshop, promotion of international cooperation among states, particularly to combat some of these crimes. The multidimensional nature of the standards means that cross-sectoral coordination will be the only way to ensure successful implementation. And this we have also seen posing huge problems in most member countries that have been assessed, in the sense that most government institutions operate in silos. They don't really open themselves to work with other institutions, particularly where it is important. And in most cases, we have seen, particularly for the discussion today, where the work done by financial intelligence units, in whichever form, is not in the end used as expected by those who are supposed to be using that information, particularly some of the law enforcement agencies for recovery of revenues and so forth. So this is mostly because there's poor coordination among some of these institutions, which ultimately impact on their performance and the adequate use of the intelligence generated by financial intelligence units. As an organization, SAMLAG, since its establishment in 1999, continues to provide assistance to states in the development and delivery of programs, studies, and technical expertise on combating financial crimes, including corruption and associated money laundering. SAMLAG has conducted 11 typology studies, among which the 2 typologies on corruption in general, which was conducted in 2009, and public procurement corruption, which was conducted in 2019, and associated money laundering in the Eastern and Southern Africa region can be mentioned. And I think these are also relevant for some aspects of today's discussion. Please allow me at this juncture to highlight some of the main findings of the 2 reports. From a technical point, it is indicated under the 2 reports that many countries in the region have made several reforms in their legal regimes, more anti-crime focused multi-year framework budgeting, accrual accounting systems, integrated financial management systems, and performance budgeting, all aimed at improving budget implementation and achieving of respective developmental goals. However, the end results appear to be quite varying. Problems, or rather weaknesses in budget implementation, are often linked to various deficiencies in public financial management systems, such as weak internal controls, lack of transparency, overriding of procedural requirements to one's advantage or when relevant, poor accounting and reporting standards, and weak procurement systems, which have often resulted in corruption and money laundering. Depending on who is involved, cases relating to violations of set-down processes hardly ever see their day in court. Further sanctions stipulated in the different laws for such violations are not effective disproportionate, or even dissuasive. For example, the laws of most things be terminated, or recommend the procuring entity that a contract be terminated as a form of administrative penalty is a constraint that most of us here can identify with, and this adversely affects budget implementation. Therefore, over and beyond a technical focus, we should be mindful of the effectiveness of our systems at both national and other clusters below national level. The SAMLAC member countries, including those in the SADC region, have embarked on numerous reforms to improve their legal and budgeting frameworks, deepen broad-based participation, and institutionalize measures to reduce corruption and improve accountability to the generality of the public, not only to the taxpayers. However, this is still much to be, I'll take that again. However, there's still much to be done in order to achieve sustainable growth and development, and to be seen to be eradicating extreme poverty, milestones which at minimum are still to obtain in many of our countries. As a matter of fact, many first and second round mutual evaluation reports of the SAMLAC countries also highlight a number of significant challenges in national AML-CFT systems in general, and with FIUs and law enforcement agencies, in particular when implementing FATF standards relating to FIU development and carrying out AML-CFT investigations using different investigative techniques. And here maybe I should also add that the main challenge we have had from member countries is that in order to implement some of these investigative techniques, they either find problems in that the legal framework is not advanced enough to allow processes which would enable law enforcement agencies to actually carry out certain investigations, particularly in complex cases like money laundering, because in most of these investigative techniques are intrusive in nature. They call on certain rights at least to be waived. This is like when you talk of computers, access to computers, monitoring of communication, and so forth. These require special processes and at times getting court orders for you or for law enforcement to be able to undertake such kind of investigation. So you find that in most countries, the legal framework is not matured enough to allow some of these processes, or to set processes of how this can be undertaken without necessarily prejudicing those who are under investigation. And also added to that, this affects the initiation of following the money principle, what we have tend to call now parallel financial investigations. Why? Because some of the techniques which are really needed to identify and trace assets or proceeds of crime will also require law enforcement to engage in some of these techniques when they're investigating, which they might not have authority or power to implement. Again, we have also seen that in as much as corruption is highlighted in most of our the jurisdictions in SAMLAC, in SADC, in the recent mutual evaluations that we have carried out, it's not really frequent that law enforcement agencies commence a parallel investigation on the process themselves. When you talk of corruption, they are actually looking at the actual criminal offense of corruption, but they are not looking at the end result of the corruption, which is what the person benefited from the corruption, or where he invested the proceeds from the corruption. So it's important that in the discussions that agencies which are responsible for identifying some of these crimes, they are alive to following the money, following the process of the crimes, and not necessarily as part of the criminal investigation, but as a separate inquiry on the benefits which have been accumulated from the offense. The mutual evaluations carried out by SAMLAG and its partners also point out the challenges currently faced by existing MFCFT regimes, and frequently highlight the lack of effectiveness of their respective national FIU and law enforcement agencies, particularly when evaluating this. I'll just cite this as examples because this is a bit technical. When evaluating FATF recommendations 2, 29, and 31, and their interpretative notes under the revised FATF standards. These recommendations speak to coordination, cooperation, the framework which should be there to enable the proper function of an FIU, and also the setting up of proper institutions to investigate money laundering and terrorist financing and associated predicate offenses. And most importantly, what I just mentioned a little while before, the powers which law enforcement or investigators should have. Because without those powers, it doesn't really add any value to talk.
Kindly unmute.
Sorry, I think there was a bit of interruption. Can you hear me now?
Yes, Mr. Joseph, you can proceed. Sorry for the interruption, but we were getting you clearly a few minutes ago.
Hello?
Yes, we can hear you. We can hear you, Mr. Jagadam. Proceed, kindly proceed.
All right, thank you. I'm not sure what had happened to, and unfortunately, I can't start my video from this end, saying you have either stopped it or crippled me. But all right, there we go. Right. Just to highlight a few issues, then I'll be done. Yes, I was just going over some of the recommendations which are relevant perhaps to this discussion. And in addition to those recommendations, I would also like to mention that they also go with specific areas where effectiveness becomes paramount in terms of how the standards are being implemented. To what extent are the standards being implemented? The institutions which we have in our own countries, are they working to combat money laundering or terrorist financing effectively? And some of these of importance, I would like to highlight immediate outcomes one, which normally which deal with issues of risk relating to money laundering and terrorist financing, as well as other predicate offenses. And then also immediate outcomes 6, which deals with financial intelligence unit, how effective they are working, as well as other intelligence gathering institutions. And then 7, which deals with investigations and prosecution of money laundering. 8, which deals with investigation and prosecution of terrorist financing. 8, which deals with confiscation issues, which we normally refer to as forfeiture in our region. And then 9, which deals with terrorist financing investigations and prosecutions. These are well provided for in the methodology which which has been set up by the FATF to assist assessment of implementation of the FATF standards. The key challenges in relation to the effectiveness part of the standards include, these are observations from the mutual evaluations that we have done in the region, a lack of a wide range of interagency cooperation, which I have already alluded to, not keeping comprehensive statistics to assist with trends and profiling of crimes and cases, the legislative framework not taking into account factors that may negatively affect the operational independence and autonomy of the FIU, which is quite paramount, because any interference with that operational independence means that the FIU will not be able to produce the expected results. Capacity constraints among the various competent authorities, including FIUs and the law enforcement agencies, lack of prioritization in allocation of resources, which may result in wasteful expenditure on less money laundering, terrorist financing risk areas, weak asset recovery frameworks, and imposition of non-dissuasive sanctions. Lack of capacity in analysis on the FIU side and conducting of parallel financial investigations or follow the money principle by investigative agencies. So in general, these are some of the common challenges we have seen in countries. The time is right for us to review. The time is right for us to review and discuss the challenges pertaining to effective combating of corruption and money laundering by linking them with issues to do with budget implementation and accountability. I'm glad to know that this session of FIUs and law enforcement agencies will discuss important issues pertaining to public finance management, which is one of the most important areas which has to be ring-fenced against corruption in all its forms and laundering of process therefore. This is a strong indication of the added value and importance of networking. This consultative meeting provides a good platform to discuss how deterrent measures can be provided through development of a legal framework focused at enhancing transparency and accountability when managing public funds, and most important of all, creating awareness on the cost of not following laid down processes. I believe that the bringing together of FIUs and law enforcement agencies in one meeting is itself part of a winning strategy for defeating corruption in the SADC region and beyond. This is an opportunity to share best practices and discuss ways to enhance the model law as well as to collaboratively combat the crimes. I am glad that the model law is designed to achieve specific objectives, which include providing for Parliament to pass performance-based budgets, ensuring that all statutory bodies and public authorities file the annual audit reports, the audited financial statements to Parliament, providing for the empowerment of public accounts committees so that they can review, examine all reports of statutory bodies and public authorities, empowering Parliament through a dedicated public financial parliamentary committee to monitor public debt and call public officials for explanations in the event of debt ceilings being exceeded. Ensuring that supplementary budgets, which appear to be improper to a quorum of the Public Financial Parliamentary Committee, be scrutinized in detail and reported to Parliament. Ensuring that international commitments such as gender-based budgeting are mainstreamed by ministries and public departments into the budget. And lastly, by providing a framework which enables Parliament to ratify public contracts which exceed 3% of GDP by a qualified majority. In conclusion, I will end my remarks by encouraging all the delegates here today to candidly share experiences on budget processes and take lessons learned back to your home institutions. Let me once again applaud the organizers of this consultative meeting and the participants who have shown commitment by attending the meeting virtually and share their knowledge during this pandemic period, which shows we are on the right track in our commitment to fight corruption and associated money laundering. It is my full-fledged hope that this meeting will discuss the various, explain the mixed results, and where there are differences to resolve and harmonize such differences by using the draft model law. This will allow customization of the model law to be applied consistent with the risk and legal context of each of the SADC jurisdictions. I thank you for your kind attention and wish you fruitful deliberations. I hope I did not take too long, and I thank you, and I will be on the sidelines listening to the deliberations. Thank you so much.
Thank you so much, Mr. Jagada. I think it's a really warm applause from the delegates that are attending today. And we really appreciate the deep dive that you have taken this meeting through, at the very, very keynote stage to remind us of the standards that have been set, that have been agreed with most of these countries, the challenges that are currently facing public financial management systems and mechanisms that can be put in place to really improve or strengthen what we sometimes see as a vicious circle and convert that or transition it to become a virtuous cycle where public financial management reinforces the reforms that are in place or that are continuing to come in to combat terrorism, to combat illicit flows and following the money and ensuring that proceeds of corruption that have already come from sources that are, illegal in their very form are not cleansed, are not undertaken or taken through laundromats to facilitate further crime. I think the linkages that you have provided provided really a strong basis of the conversations that will take place today. And, at this early stage, without taking too much time from the session, allow me to just, point out key things. One, the fact that standards that are in operation are already derived from globally agreed internationally accepted relevant instruments in that combat the anti-money, that combat laundering, so to speak, and that combat the use of financing for terrorism. The other thing I think I just want to make emphasis that we have drawn from your speech so that we don't forget it as the conversation begins is really the importance of putting in mechanisms building or strengthening much needed opportunities through different mechanisms, the administrative sanctions, the performance-based budgeting, the strengthening of legal and financial mechanisms that strengthen accountability, the disallowment of proceeds of corruption into the mainstream, support of processes that can allow for intrusive investigations that can arrest these issues. I think these are very important things. And, I picked some of those just to bring them back to the table, back to the conversation, so that we can remember those points as we move into the formal, presentation of the PFM model law by Dr. Greenberg. But without preempting what Dr. Greenberg will be saying, I would like to take this opportunity to call upon our media team to share with us a video clip that reinforces some of these key messages that Mr. Jagadam has shared with the delegates team before we move into the presentation of the SADC model law on PFM by Dr. Greenberg. Over to you, media team, and just to take us through. Thank you.
Countries lose an estimated $88.6 billion. Every year, African countries lose an estimated $88.6 billion as illicit capital flight, according to the 2020 edition of UNCTAD's flagship report, Economic Development in Africa, entitled Tackling Illicit Financial Flows for Sustainable Development in Africa. Today, we're unpacking the issue of illicit financial flows out of Africa with Paul Akawumi, who's the director of UNCTAD's Division on Africa and Least Developed Countries. Paul, thanks for being with us.
Thank you for having me.
Paul, before we get into the details of some of the impact that illicit financial flows have on the African continent, could you help us better understand what exactly we're talking about when we use the term illicit financial flows?
In the report, we define illicit financial flows as movements of money and assets across borders that are illegal in source, transfer, or use. And they can take the form of tax and commercial practices, illegal markets, terrorist financing and theft, or corruption. Tax and commercial practices represent the greatest issue for Africa. Up to 65% of illicit financial flows, according to the UNECA estimates. Illicit financial flows also occur through trade misinvoicing, typically the under or over invoicing of commercial transactions. The report focuses on illicit capital flight, which are defined as the outflows of financial resources from a country in each period that are not recorded in official government statistics. And we found that illicit capital flight from Africa reached $88.6 billion annually between the years of 2013 and 2015. Clearly then, illicit financial flows are a significant and a shared problem between developing and developed countries.
Paul, would it be fair to say that some sectors are more vulnerable than others?
Absolutely. In Africa, the extractive sector, the telecommunications sector, and the financial services are the most vulnerable sectors to illicit financial flows. Since most countries in sub-Saharan Africa are commodity dependent, export flows related to commodities are a focus of this particular study. In 2015 alone, according to our estimates, Africa lost at least $40 billion in primary extractions of resources and between $30 to $52 billion to trade misinvoicing. Misinvoicing occurs primarily with high value, low weight commodities, such as gold, diamonds, and platinum being particularly vulnerable. And in gold alone represents 77% of all total under-invoice exports. Diamonds representing 12%, and platinum representing 6%. And all the other exports make up the 5%.
And what about countries, Paul? What did the report find? Have some countries been more affected by illicit financial flows than others?
When we look at the capital flight estimates, the top 5 countries with the highest illicit financial flows as a share of GDP, and we have to look at for the data that is available, are Sierra Leone, Congo, Seychelles, Burundi, and the Democratic Republic of Congo. The 5 countries with the lowest level of IFFs as a share of GDP are Algeria, Sudan, Cote d'Ivoire, Kenya, and Morocco.
Now, Paul, we've mentioned several times that illicit financial flows cost African countries an estimated $88.6 billion, which is equivalent to about 3.7% of GDP. So could we talk about some of the socioeconomic consequences of illicit financial flows?
There are tremendous impacts. Illicit financial flows are not only a drain on domestic financial resources, but they are also correlated with lower government spending on key areas for development. The results of our model show that countries with high illicit financial flows spend 25% less on health and 58% less on education compared to countries with low illicit financial flows. As a result, women and girls are disproportionately negatively affected by IFFs, as they are the majority beneficiaries of public health and education expenditure. The report also finds that illicit financial flows are negatively associated with labor productivity growth, undermining productive capacity and achievement of the Sustainable Development Goal number 8 on decent work and economic growth. In countries with high illicit financial flows, agricultural productivity is 67% lower.
Paul, in your answer, you mentioned Sustainable Development Goal 8, which is the goal focused on decent work and economic growth. I'd like to talk a little bit more about the Sustainable Development Goals. The report says that curbing illicit financial flows could help reduce Africa's Sustainable Development Goal financing gap by half. Could you explain a bit more to us what that means?
We mentioned earlier on that $88.6 billion US dollars is capital flight out of Africa. And that's nearly half of the estimated $200 billion US dollars needed annually in Africa to achieve the Sustainable Development Goals. This money could have compensated for the 60 to 90 billion US dollars that the African Development Bank estimates is needed annually to provide universal electricity access by 2025. Recent estimates by the African Development Bank, this 2018, suggest that the continent's infrastructure needs amount to between 130 and 170 billion a year, with a financing gap in the range of 68 to 108 billion. Potentially then, illicit capital flight could cover almost all of the infrastructure financing gap to meet the related SDG targets.
And if we're able to see just how much illicit financial flows cost African societies and economies, and we're also able to identify the sectors that are more vulnerable, why has it been so difficult for African leaders to stop these illicit financial flows out of the continent?
Good question. Illicit activities are, by their mere nature, inherently difficult to record. And this is due to the differences in legal and regulatory frameworks across jurisdictions. For example, it is difficult to separate illegal actions, for example, tax evasion, from illicit and licit practices, for example, aggressive tax avoidance and lawful tax planning. Now, efforts to stop illicit financial flows on the continent are constrained also by the lack of statistics. The measurement of trade-related IFFs in Africa is critical to combat them. However, such information is typically scattered across a range of institutions at the country level, And there is no single data source from which to derive these relevant statistics.
So, Paul, what recommendations does the report make?
Well, in the report, we propose a 10-point plan for tackling illicit financial flows in Africa, which centers on meeting the Sustainable Development Goals. Within this framework, we suggest coordinated action by a range of stakeholders. Firstly, at the institutional level, the policy guidance aims at contributing to multilateral cooperation to combat illicit financial flows. And at the domestic level, the regulatory framework must be strengthened. Data collection and reporting on trade, including at the transactional level, should be strengthened. Enhanced regional cooperation on reporting standards for firm-level tax and commercial information is also needed. Now, African governments should seek to collect more data and better data, potentially incorporating the use of UNCTAD's automated system for customs data, ASICUDA, including its special Mineral Output Statistics Evaluation System, MOSES. Now, national data should also be reported to international databases such as UN Comtrade. In many ways, addressing illicit financial flows is a matter of ethics, and civil society organizations, whistleblowers, and investigative journalists have played a critical role in revealing the magnitude of IFFs and the mechanisms that support them in Africa and beyond. Transparency initiatives must be encouraged and continue to be encouraged, including their use in new technologies.
Thanks, Paul, for helping us unpack the issue of illicit financial flows out of Africa. And this is the subject of the 2020 edition of UNCTAD's flagship report, Economic Development in Africa.
Thank you very much. Thank you very much, media team, for provoking our thoughts and this conversation with that video clip. Now, following a strong and very, very inspiring, opening remarks from the Secretary General, then with the deep dive that Mr. Jagada has provided, the provocation from the video really sets pace for us to welcome Dr. Daniel Greenberg, who is a barrister specializing in legislation and legislative process. And Daniel Greenberg, a very warm welcome to you, Doctor. He is the legal drafter of the SADC PFM model law. Dr. Greenberg has over 30 years experience in legislative drafting and machinery of government. He currently serves as counsel for domestic legislation in the House of Commons and serves also as a general editor in Westlaw UK Thomson Reuters. Dr. Greenberg has studied law at the Cambridge University in England. He edits 2 legal dictionaries and an international legal journal, has worked in governments and parliaments in various parts of the world. Name a few. And we are really privileged to have Dr. Greenberg taking us through the PFM model law that he has continued to draft with the support of the technical team that is supporting the process. And we are glad that, in addition to his extensive experience, he really has a lot more to share in training, in teaching, legislative skills, including intra-government and external consultation processes. So allow me to welcome Dr. Greenberg to this consultative session with the with the financial intelligence units and anti-money laundering agencies of the SADC member states. Over to you, Dr. Greenberg.
Thank you, facilitator. Good morning, distinguished delegates and esteemed colleagues. Distinguished facilitator, Madam Secretary General, and the distinguished keynote speaker. I will shortly try to share my screen and take distinguished delegates through some specific key points of the model law that are likely to be of particular interest to today's deliberations. Before I do that, I wish to make two background points that underpin the way the model law has been crafted and will explain to distinguished delegates the assumptions of policy and strategy on which the provisions of the model law rest. Madam Facilitator, you have rightly drawn attention to the work of the technical working group, of which you are an ornament, and that working group has been of inestimable value in enhancing and shaping the refinement and development of the model law so far. And we look forward, Madam Facilitator, to the expressions from delegates today, adding to the many valuable issues that have been raised during these consultative forums, which will certainly further enhance the model law under the care and supervision of the technical working group. The first underlying point to which I allude is one that will be familiar to all those present who are distinguished lawyers themselves, and many of whom will have considerable experience in the drafting of legislation. And that is the need to effect a balance between a number of different conflicting and co-relevant desiderata that require to be reflected in the model law. First, simplicity and clarity. It is very important for a number of reasons that this model law be expressed in a simple way and a simple form. Not just that the language should be suitable for comprehension by as wide a range of people as possible, but also that its form, both in terms of brevity and structure, should speak to as many of the target audiences as possible and should invite understanding and comprehension. But it is also necessary that the needs of certainty are served by this model law. It must be something that can be taken and applied by SADC member states in accordance with their own domestication procedures in a way that is really effective. So it must not be merely a series of platitudes or pious hopes. It must provide certainty as to the legal and legislative expectations of a SADC member state in relation to transparency, accountability, and other fundamental principles of public financial management. So that is the first balance that we have tried to effect. Second, and related, accessibility and accuracy. As well as being as simple as possible, in other ways, the model law must aim to be accessible through its language, its structure, and in other ways, including the accretion of explanatory material. It must aim to be accessible to all. Madam Facilitator, I was struck a few weeks ago at one of these consultative forums by hearing a video clip in which young citizens of SADC states gave their views about public financial management. One might think that most young citizens didn't have many views about public financial management, a rather dry and technical topic, and it was interesting to find that that was certainly not the case. There was significant appetite by young citizens to treat this as a terribly important topic that has direct impact on all their lives. And there was certainly a willingness to engage, an enthusiasm to engage with the underpinning principles of the model law. And that, I think, is a lesson to all of us in relation to maintaining accessibility as one of the fundamental principles, but it has to be balanced against accuracy. And therefore, it has to be balanced against the use of technical language to describe technical concepts. It has to speak at a level of accuracy to all the public officials and others who will be required to implement and enforce the model law, and that is the second balance that requires to be struck. Similarly, matching the certainty about which I spoke, clarity. The provisions have to be clear and certain, but they also have to be flexible, and that is very difficult to achieve. I direct in particular, as a particular example of the difficulties that this necessary balancing process raises, I direct the attention of distinguished delegates to that part 12, that deals with the regulation of crypto assets and cryptocurrencies. The model law perforce requires to address the issue of cryptocurrency, which, as well as being in general a major developing challenge for public financial management, central banks considering whether to issue their own, how to regulate those issued by others, as well as those matters, the issue of illicit financial flow, corruption is now increasingly tied up, money laundering indeed increasingly tied up with virtual assets of different kinds. It is therefore inconceivable that the model law would not address these matters. Apart from anything, a state that does not issue a cryptocurrency is nevertheless exposed to valuation and classification issues arising in respect of cryptocurrency by virtue, if nothing else, of their state-owned enterprise involvement, of procurement issues, and of course, simply by reference to on-lending and government securities of a wider range, some of which will inevitably be involved in crypto asset transactions at some point in the supply chain. And yet, once again, yes, we would like to be accurate and clear and certain, but how can we? Because this is something that is changing before our very eyes. Anything we would say with complete certainty about cryptocurrencies would be doomed to obsolescence before the model law had been adopted, far less before it had been implemented. We have therefore had to try to use a number of mechanisms to combine the necessary flexibility to develop in accordance with real-world changes, with real-world refinement of the crypto asset currencies and crypto assets more generally, to combine that flexibility with the necessary starting certainty. To that aim, distinguished delegates will see when they peruse part 12, they will see that we have based ourselves as a necessary starting point on principles articulated by the London School of Economics and Political Science Institute of Global Affairs, basic principles for regulating crypto assets, fourth draft, but we take that very much as a starting point from which we can move on. Finally, in the matter of balance, we have to balance a principles-based approach that supports simplicity, accessibility, and clarity with enforceability that again requires consideration to be given to, in particular, sanctions, criminal sanctions, and other sanctions of a kind to which I will advert later. Secondly, the domestication process has already been alluded to by Madame Secretary General, and I draw the attention of distinguished delegates to the fact that footnotes in a number of places in the model law remind the reader that contextualization set against the constitution and other legislative provisions of each SADC member state requires to be effected during the domestication process. There are a number of ways in which different constitutions vary as to the amount of detail they already cover, or they mandate other legislative provisions to cover in respect of matters dealt with by the model law, and obviously overlap or indeed conflict is to be avoided at all costs in the domestication process. With those two opening comments, I will now attempt to share my screen and take delegates through a few key issues. Could somebody from the Secretariat please confirm that distinguished delegates are now able to see my screen?
Yes, Mr. Greenberg, we are able to see.
Thank you. Part 2 achieves the universality and accessibility that I described earlier by establishing aims and objectives not merely in the preamble, as is sometimes done, but as operative provisions of the law themselves, that the courts will recognize as being substantive legislative propositions and which the courts will give effect to in accordance with the principles of administrative law. Those aims include a purpose for the Act to foster accountability, transparency, independence, and modernity through efficient and effective processes in relation to raising public revenue, spending public revenue and resources. And we look at resource accounting and not cash accounting, as will be seen later, accounting and parliamentary oversight. Particularly important in order to ensure citizenry confidence. Clause 10 requires measurable outcomes to be aimed, to be made targets by public officials for the optimization of public revenue and expenditure, for preventing unauthorized expenditure, for sustainability and accountability and oversight. And it mandates the relevant minister to operate a scheme specifying measurable benchmarks that can test and demonstrate the testing of success in achieving those outcomes. Clause 11 articulates public financial management principles, transparency, accountability and participation, citizenry, third sector, social sector, accountability and participation, oversight focused primarily on Parliament and the parliamentary bodies, including the National Audit Office and sectoral regulators, and responsibility, speaking directly to the morality and responsibility of public officials and bodies, while also providing for effective methods of sanction and enforcement where necessary. By way of further articulating the values that underpin the responsibility principle, Clause 12 identifies core public service values: integrity, independence, impartiality, equity, professionalism, accountability, and responsiveness. In part 2, finally, Clause 12 makes provision for the contextualization by reference to the Constitution to which I referred earlier. Part 3 identifies key authorities in the implementation of the model law: the Finance Minister, the Finance Secretary as head of the Permanent Financial Secretariat, with their functions given a level of certainty, as I discussed before, and their powers of inspection. The Finance Ministry is adumbrated on the face of the Act, as are the responsibilities of accounting officers within each public body responsible for finance. The Auditor General is not dealt with in detail in Part 3 because that office is dealt with in more detail later on. Part 4 sets out the main principles in relation to the fund management. At earlier parts of the consultative process, we have been encouraged to take away the issue of special funds, including sinking funds, and consider making additional provision about them, and we have undertaken to do that thing. There are some special accounts already mentioned, including retention accounts and trading accounts and debt servicing accounts. Part 5 deals with the standard supply and appropriation process. Part 6 deals with the standard parliamentary control process. Parts 5 and Part 6 are expressly subject to individual parliamentary processes and standing orders. Nothing in the model law sets out to prescribe to SADC states, parliaments, how they should exercise the supervision and control. That is, of course, a matter for the parliamentary sovereignty and the exclusive cognizance of each legislative assembly. Nevertheless, Part 6 does articulate a parliamentary engagement principle, that Parliament should use the full range of mechanisms available for the purpose of overseeing and controlling the public financial management process, and there is a non-exhaustive list given that is again expressly subject to and in accordance with the standing orders of Parliament. The Auditor General's status and functions are set out at this point in the model law in some detail, including the independent status of the Auditor General. We have been asked to take away at an earlier stage of the consultative process, to take away these clauses and see whether we can decouple them from regulations made by ministers even on administrative matters, in order to further accentuate the independence of the Auditor General. It remains therefore to be discovered how one makes the necessary administrative regulations, and that is a matter on which we will have to consider further. The Public Accounts Committee is given, along with the Auditor General's reports, detailed explanation in the model law, and the reports are, of course, to be published along with responses to the reports in order to enhance transparency and accountability in oversight. For accountability, the Public Accounts Committee is mandated to operate a public complaints portal, which feeds directly back into the parliamentary scrutiny process. Whistleblowing, something that distinguished delegates will recognize as of particular importance, is given a required statutory status to ensure that actual possible financial irregularities can be exposed, because as distinguished delegates are much more aware than I am, without whistleblowing mechanisms, irregularities will rarely be exposed in an effective way. Part 7 deals with the budget process, including parliamentary control. Flexibility, which I mentioned earlier, has to be provided for by environment and in-year variations, but always within a mechanism of oversight that controls the variations and keeps them within standard and controlled ranges of variation and purposes of variation in the case of environment. The budget process based on estimates is discussed, and a particular emphasis is made on specific accompanying documentation, including departmental objectives, sustainable fiscal policy to enhance sustainability, sustainable development goals to expand the range of sustainability, international commitments and project statement, particularly important for donor and other convention concerns, equality and diversity to enhance citizen engagement, past year and future year implications, again, multi-year budget projections, and all to permit flexibility within an overall containment strategy, and finally, the public debt statement. Part 8 deals with government borrowing and begins with classification, as well as leading into a debt management strategy. So the strategy is based on a broad and purposive understanding of the classification of government debt, including government securities in the widest sense, and other borrowing, including on-lending and wider mechanisms, including guarantees and indemnities. The public debt statement, to which I have already referred, is required as a budget document, and further detail is given about it along with the public debt schedule, which is required to be appended to the public debt statement tabled at the budget. Debt ceiling is dealt with in clauses 84 onwards, and that is again a process-driven rather than a prescriptive substantive mechanism, requiring different mechanisms to apply greater control when the ceiling is met. Part 9 deals with procurement, which is of course of central importance in relation to preventing illicit currency flows and preventing misuse of public funds in general. Part 10 deals with the principles and practice of public accounting procedure, and as I said earlier, requires a focus on resource accounts rather than cash accounting to give a true and fair picture of the widest possible understanding of government accounts within a whole of government account envelope. Part 11 creates offences applicable to all public officials of public financial misconduct and misuse of public funds. Maladministration, which deals with some of the evidential difficulties attendant upon prosecutions for misconduct and misuse of public funds. Maladministration is not made an offence by the model law, but it is linked into the identification of officials, leading to the possibility of disqualification by Parliament for certain public offices within Parliament's control, thereby preserving the separation of powers. Part 12 I have already described in relation to cryptocurrencies, and part 16 I need to mention only in relation to the flexibility supplied by an ability for the minister to make supplementary regulations and to issue guidance, but both those regulations and the guidance are expressly subject to parliamentary control and scrutiny, thereby ensuring that there is no democratic deficit in relation to those matters. Madam Facilitator, I hope I have given a sufficient adumbration of core parts of the model law, and I look forward to receiving the comments and questions of distinguished delegates and esteemed colleagues present here today.
Thank you very much, Dr. Greenberg, for taking the distinguished delegates through the provisions of the PFM model law. And, you know, it really is a round of applause to you two for, you know, the patience and particularly even at the beginning, unpacking the key, the thought process that has gone through this, the key tenets, ensuring simplicity and clarity, the management of the various desiderata, as you very rightfully called them, and how this product has actually gone through the process and with quite some input from the technical committee that has been walking the journey with you. And it is at this point that we really wish to open the floor for input. I believe that our distinguished delegates, participants in this session today, I think you can see the kind of attention, investment of content that has gone in all morning, and we really thank you for the kind attention that you have continued to pay. So it is at this juncture that we open the floor for input from the floor, from the different delegations represented here. And at this point, I will not push for the specific countries not yet. I would just like to open it up for any burning issues, comments, questions, and input that the delegates would like to raise, and ask any points of clarity that you may seek. We really open the floor. We request you to utilize your reactions bubble, at the bottom of your Zoom screen. You have an icon there for reactions, and please feel most welcome to raise your hand so that we can pay attention to your comments, observations, or questions that you may be having. And please feel free to make comments for all the interventions that have gone ahead, right from the beginning when we had the Secretary General, Madam Boemo Sekoma, open this session, to the very deep dive that we had from Mr. Jagadam, and to the exposure and to the presentation that Dr. Greenberg has taken you through. The floor is open. The floor is open. Please feel free to raise your hands. Feel free to raise your hands. If we do not have burning questions from the floor, I will go back and call out the countries to make interventions per delegation. Okay, we have South Africa. Yes, Peter, the floor is yours. Please feel free to come in. Thank you.
Yeah, thank you so much, and thank you to the presentations and the insight. Maybe just in terms of the financial intelligence units and the funding models, there is currently work being done and a project being proposed in Egmont. Egmont is the group of financial intelligence units globally, sharing some best practices and information with one another in terms of FIUs. So the specific project that's proposed is around the funding models of financial intelligence units, to get an idea of how is a financial intelligence unit being funded by various countries. Interestingly enough, there was a survey done just to kick off the project, and a low number of FIUs, and that's possibly be 160, around 170 that could have responded to the survey, but most of the survey respondents were from Africa in terms of highlighting the funding models being used in the region. I think interestingly enough from that, and some of the proposals around that, is how do we fund the work of FIU being an important role player in the fight against money laundering and terror financing. Some of the proposed models that's been deployed is where government fully fund the work of the FIU, so you heavily depend on the government to fund you, but then you also go into a governance system where you comply with the framework of governance in terms of applying for funding and then also the spending issues. The next funding model that was raised is where you rely on industry levy. So for instance, the Financial Intelligence Unit would regulate the banks. So the banks would then contribute to the work of the Financial Intelligence Unit. Then we've also seen some FIUs that rely on the funding that's been collected in terms of administrative penalties being issued by non-compliance institutions. There is also a number that relies on donor funding, where they get donor funding in terms of their work. So I guess all of those would add up to a situation where you would look at the independence of the FIU and are they reliant on these funding to do their work, and ultimately will it impact on the independence and of the work of the FIU. So I think a very important topic to raise. I think another topic that I just want to put on the table, our Auditor General in South Africa recently made some amendments to the legislation. So previously they would report their audit findings to the auditee. So if they would audit a specific department, let's call it the Department of Health, if they found something wrong in their audit processes, they would then report that to the management and expect the management to fix that. They made some changes that they can also report now incidents of when they found some illegal activities to institutions like the Financial Intelligence Unit. We as the Financial Intelligence Unit also added the Auditor General as a recipient of our financial intelligence. So if we've received reports, for instance, in particular to a specific government department, we can prepare a report to the Auditor General to kickstart an audit process or to inform the audit process, or we can reactively respond to a request from all of these, or from the Auditor General. Then just lastly from our side, we in the COVID times, we all of our governments experienced the increase in spending. We've seen it, and then coupled to that is typically an increase in possible fraud and maladministration and possibly corruption. So we've created a multi-agency task team where law enforcement agencies work together. And in that task team, we heavily relied on data that was shared with us by the Auditor General. So when they started to do proactive analysis of data, even before the financial year was concluded, some of those data were shared with the Fusion Center, which started off very early investigations and some successes around that. Thank you for the opportunity.
Thank you very much, South Africa delegation. Thank you, Peter, for your intervention and for sharing developments. I think at this stage, with the permission of Dr. Greenberg, I will take a few comments from the floor and then open up for conversation. So allow me to follow through if we do not have a burning comment up. Okay, we have Madagascar. Madagascar, please take the floor. Please take the floor.
Merci de m'avoir donné la parole. Ce n'est pas une question, mais des observations. Après analyse de ces trois types, je n'ai pas de remarques à faire en tant que service de renseignement financier sur l'application des lois, mais par contre, j'ai pris note sur quelques articles qui sont généralement incohérents à la structure étatique et la réalité à Madagascar. Plus précisément, la structure et le fonctionnement des ministères sur la gestion des finances publiques. Je remarque seulement car je pense que d'autres observations ont été déjà relevées par les acteurs budgétaires malgaches lors des précédentes réunions. Primo, à la partie 3 intitulée « Autorité », article 15 et 16 concernant les secrétaires aux finances. D'après la définition prévue dans ce projet de texte, les secrétaires aux finances, c'est le secrétaire général du ministère chargé des finances. Article 15, alinéa 1. Mais à Madagascar, ces attributions sont totalement différentes à celles citées dans ce document type. Sinon, la règle de séparation du pouvoir entre l'ordonnateur et le comptable public est effective depuis longtemps. Par contre, si on réfère aux articles 16, 16 par 1, petit a et petit b, 16 par 2, petit a et petit b et petit c dans ces projets, on a l'impression de constater le contraire. Autre point que j'ai pris note, c'est sur la désignation des comptables à l'article 21. Je précise tout simplement que chez nous, les pouvoirs de nomination reviennent au ministre, mais non pas au secrétaire général. Juste une remarque. Merci, mesdames et messieurs, d'avoir pris en compte mes observations. Merci.
Thank you very much, Madagascar. The points are very well noted, and we will have an assurance when the response time comes. Thank you very much for your contribution. We welcome more hands from the floor, and we also invite you to make any written comments you may have into the chat box, and our media team will also provide an email address, if you feel that you can strongly, make your case in a written format, and we really encourage that. So thank you, Madagascar. You can lower your hand. I would like to go ahead and call upon the Angola delegation. Angola delegation, if you're in the house, we welcome you to give your remarks. Angola delegation. If you're not in the house or if you're not ready, we would like to welcome the Botswana delegation. Botswana, FIUs from Botswana. Any representative is welcome to take the floor.
Oh, okay, good afternoon. I hope I'm audible.
Yes, thank you.
Yes, well, this is just to welcome the proposed law, and we are very much enthusiastic about the inclusion of cryptocurrencies in the law, because it's an area that I believe all of us are still trying to wrap our heads around the regulation, around their links with the financing of terrorism and also money laundering issues as a new way of transacting, if I may call it. And I must also indicate that insofar as the Public Accounts Committee issues are involved, the issue of whistleblowing or allowing whistleblowing to the public account of committees, one of the issues that will also assist us as a country, and I believe, and also to fellow countries, because most of the time, as it has already been indicated, governments operate in silos, and there isn't really much accountability, even to the Public Accounts Committee. So when we have issues such as allowing whistleblowers to report maladmin or any issues that they have in relation to the management of public finances, this would also help us as financial intelligence units to have information or the trickling in of such information in the form of reports to us that would assist in us being able to nab criminals or to stop them in their tracks insofar as laundering is concerned. We all know that as African countries, we have issues of corruption, and we cannot divorce corruption from issues of maladmin or misappropriation of public funds. So we also believe that empowering Parliament to be able to look into these issues, and more importantly, the Public Accounts Committee is an issue that would work for us as a country, and I believe to also our fellow countries. Thank you.
Thank you very much, Babuya from Botswana, and on behalf of the Botswana delegation, I think these are very key points you're raising. The space, the place, and the importance of whistleblowing, cryptocurrencies, and the mystery that or risks that could be behind that, and issues of bringing maladministration issues to the floor to really help manage the stretched capacities that are likely to be. And this really links to even an earlier question to South Africa, where the issue of financing even the FIUs needs to be conversed and expounded on, the empowerment of Parliament, and ensuring that in as much as there could be a swell of conversation coming from the public, there needs to be the necessary capacity to manage that. I will pause there and bring it back to Dr. Greenberg. Dr. Greenberg, any observations, any early responses that you could share with the representative of the delegates from South Africa, Madagascar, and Botswana before we carry on? Over to you, Dr. Greenberg.
Madam Facilitator, I am enormously grateful for the contributions made by those distinguished delegates. In response to the points made by the distinguished delegate from South Africa, I would say that if he were able to provide us with some details of the work in progress to which he alluded at the beginning of his remarks, that would be particularly valuable. I am not, based on his observations, I'm not sure yet how extensive the interface is between that international work and the model law itself. But from what he was saying, I'm clear that we will wish to reflect it, even if very little of it appears on the surface of the model law provisions, but that is a matter for further consideration. And if he were able and willing to provide some details through the SADC Parliamentary Forum Secretariat, that would be enormously valuable. And the learned moderator, the learned rapporteur of today will have taken careful note of the points that the distinguished delegate from South Africa made, and we look forward to any written expansion that he is able to offer. In relation to the point made by the distinguished delegate from Madagascar, I confirm that, as I said in my presentation, contextualization will form part of the domestication process. And in relation to the specific provisions that he mentioned, clause 16A and clause 16A and B and clause 21, I confirm that those are indeed expected to be contextualized as necessary by implementing SADC states. In relation to the remarks of the distinguished delegate from Botswana, I am particularly grateful for the support in relation in particular to a preliminary and flexible regulation of crypto assets, the underlining of the importance of whistleblowing provisions, and the comments about the centrality of the Public Accounts Committee, all of which are valuable support of the underlying principles upon which our model law is based. I am grateful to all delegates for their comment.
Thank you very much, Dr. Greenberg. We now open the floor once again and call upon Comoros. Comoros representatives, if you're in the house, we welcome you to take the floor and make your observations. Comoros. Okay, DRC, Democratic Republic of Congo. DRC, if you're in the house, kindly take the floor. DRC. Okay, Eswatini, representative of Eswatini. If you're in attendance, the floor is yours, Eswatini. Okay, how about Lesotho? Lesotho, do we have a representative in attendance?
Yes, we do. We do not have much comments at this stage, but I guess we would like just to also echo the sentiments of Botswana, first of all, by saying we are anticipating the new law and we welcome it as well. More especially for our interest as well would be sitting with cryptocurrency, as it is fairly a new phenomenon for everybody across board. And we I'd like to think that we're still all in learnership of how to deal with it. It is quite tricky, we must admit, and especially for a space like us with lack of resources. I think we are all ears. We're just in a space of learning at this point. Thank you so much.
Thank you very much, Tenjiwe, delegation of Lesotho. Thank you for your input and observations and even support for the remarks that have been made beforehand by Botswana. We've already had observations from Madagascar. And if there's anything more, Madagascar delegation, you can let us know. So allow me to move to Malawi. Malawi delegation. Malawi delegation, the floor is yours. If you're in the house, please take the floor. Malawi. Mauritius. Mauritius, I do recall Mauritius was in attendance at the beginning. Mauritius, would you like to take the floor?
Yes, thank you, Madam Chair, if I may.
Yes, please.
Yes, so we have no comments so far, but we welcome. We've gone through the model law. We welcome the proposal. It's very well drafted, and just to share a little bit the experience of Mauritius, especially with regards to the procurement aspect, which we find very interesting. We do indeed have a law regulating procurement in Mauritius, but especially with regards to the emergency procurement part, where we have investigations ongoing with regards to corruption and money laundering, especially in the wake of the COVID, where we had to procure emergency, we had to go by way of emergency procurement with regards to COVID materials and medicines. And we'd just like to know, maybe eventually the model law will have to be contextualized in the local context, because we find it that the model law is a bit general in nature. But what would like to know, like more specifically, how to especially tackle issue of emergency procurement, where government officials have large discretions to procure materials or goods based on the pretext of emergency. So this would like to know how to handle the situations where a huge amount of discretions are used in those respects, which give rise to corruption and eventually money laundering. That's one aspect, one observation in light of our experience. And secondly, we welcome also the aspect on cryptocurrency, virtual currency, which is another novel aspect that we have to look into and further consider. So with that, I'll say thank you, and I'll await comments on those. Thank you.
Thank you very much, Rupchand, and the Mauritius delegation. Most appreciated. You could hold on a little bit so that we can check on Mozambique. Mozambique, any input from the Mozambique delegation? Mozambique. Namibia. Namibia delegation. Namibia delegation, if you're in the house, the floor is yours, Namibia. Seychelles. I think we already had input from South Africa. We've already had quite extensive and good input from South Africa. Tanzania delegation.
Thank you very much, Madam Facilitator. We appreciate for the presentation and the insight on the model. I've got very few remarks. The first one is on the post versus pre, because the way I see the model is concentrating on the post-mortem. I just request if we emphasize on prevention, where we prevent from the abuse of the crime happening. And I know that there is a budget review committees and whatnot, but in most cases those are post-mortem rather than the pre. And another thing is I'll take you to the nature of our country, Tanzania. We have got the level of the local government and the central government. The local government has got the councillors, where they oversee the budget of the local areas and the expenditure and whatnot. So I would request for the model to include sort of a PAC at the level of the local government councillors. And another thing is on the cryptocurrency. I would like to request that the cryptocurrency in most countries is not yet recognized legally. So before we put it in a law, we have to find a way of, first of all, recognizing it and seeing how it can be managed, and it can be we can prevent the abuse of it. Because I know it's a new technology, it's new to most countries, but before we put it in a law which is a general one, must find a way to have a separate way of recognizing it, legalizing it, and understanding the players who does what. Another thing is there is an element of external financing in the budget. I would like to see how we insist on a scrutinization of the sources of the external financing in terms of its legality, especially when it comes from the private sources, apart from let's say the World Bank or other bodies. There must be a mechanism of scrutinizing the sources, which can have a higher level of scrutiny than the normal practice. The last one is having an element of sorry for the background noise, having an element of reporting to FIU whenever there's a suspicious thing which happened. Let's say the PAC noticed something and is suspicious, but it has not made a conclusion on that. The lawyer should require the PAC or any other body, when it is suspicious, to report to FIU rather than FIU waiting for the reporting entities like banks, which can be very late. And the last one is just to know, because we are new in this thing, especially you told us this is a 6th meeting, what will happen to our current laws? Will the model law be like now we have to replace what we have, or what will be the fate of the current laws which we are having in our countries? Thank you very much.
Thank you very much. Asante sana Kiongozi Limo. Thank you very much for the in-depth remarks, very reflective remarks from the Tanzania delegation, and a little bit of holding up on that as we organize the response. May I call upon Zambia delegation? Please take the floor.
Thank you, Madam Moderator. Speaking from Zambia, if you allow me, I'll have a few remarks, and then our Director of Finance will also add. We're so grateful for this opportunity to participate in this important process. I think it's very timely. Without getting too much on our local issues, I think we wanted to highlight that actually there was a project done under SMLAG on public procurement corruption. And one of the issues that came out is that one of the vulnerable areas why we have these issues coming up now and then is because we don't have a model law in SADC on public procurement. So it's very exciting to see that we're actually getting a model law on public financial management. On an observation from the model law, and maybe a question, one of the areas that FIUs and law enforcement agencies deal with at the end of the day is this issue of forfeiture of assets. And it's come out in many discussions that the management of forfeited assets is not yet at the level where we're getting the benefit from these assets. I wanted to know whether there's a possibility of expanding the scope of our public finance management. For instance, when you look at the purpose of the Act, B says expenditure of public money and other public resources. C is accounting for receipts and expenditure of public money. I was thinking if perhaps somewhere here we could be talking about accounting beyond that which we receive and which we expense. And this is the issues of the assets that come under our custody in the different agencies after we've done forfeitures. I think this would really help to create some sort of standards on how assets are managed. I think right now a lot of different countries, institutions are working on coming up with models, but I think it's maybe taking a bit of time, and maybe it's also being done in very various layers. Excuse me. So I think that's one proposal that we would be making as Zambia, that if there's a possibility of looking at managing forfeited assets under such a law, that would really be helpful. We also wanted to share that in terms of the FIU here, we're actually working on a project on quantifying illicit financial flows. We started out with seeking for technical assistance from the Italian FIU because they've done a project of this nature before. And we're now currently co-opted in a UN project. I'm not sure how many other agencies represented on this call may be on that project, but I think this is a worthwhile project that the SADC team could also look into. Perhaps there are insights to be gained given the work that you're doing on this particular model law. Lastly, from me was just to agree with Tanzania that we should be looking at ways of the Public Accounts Committee, the Parliamentary Accounts Committee, sharing information that they receive from the different submissions they get with law enforcement as well as the FIU. Right now in our country, I think we're seeing a number of reports that PAC is receiving, And we are actually sending out requests to them to see how we can tap into that information. And we're happy to note from the model law that we're expanding the scope of information that can go to PAC. We note the observation that PAC usually gets information from the Auditor General's reports, and that we wish to expand this to other reports. For example, financial intelligence units do typologies, and those are good reports that PAC could also get information from to see the different methods, the risks that are there in relation to money laundering and terrorism financing. I'll pause here, Madam Moderator, and ask Mr. Zimba to step in from Zambia as well. Thank you.
Thank you, DG, and thank you, Madam Moderator. My name is Victor Zimba, as the Director General has mentioned. I'll start mentioning that, yes, this is exciting that we are having a model law. I think it will be helpful in providing comparative analysis, even as we administer these laws around public financial management. You may wish actually to know that in Zambia, our latest act is Act number 1 of 2018. That is the Public Financial Management Act. So it's interesting to be able to see some of the proposals that are coming in the Model Act. Just last year, Zambia enacted the Zambia Public Procurement Act of 2020 to deal specifically with procurements. And then the further, I think, interesting aspect is that of the cryptocurrencies that has been proposed. We further like what Tanzania submitted, that it's interesting that a number of jurisdictions are yet to grasp with just how to recognize these. So it would be interesting to see how this pans out. Would even propose further to that this is instead of just narrowing down into cryptocurrencies, so it's expanded to, for example, capturing the full array of virtual assets, so that we see how the SADC region is dealing with those areas. My comments, Madam Moderator, is on two aspects. And again, this is adding on to what Tanzania said, to say that a number of laws are more reactive than proactive. They are meant to deal with matters after they occur, rather than to prevent. And on that note, I would like to observe, especially from the sections that are dealing with the debt contraction. We had a situation in Zambia where we had, proceeds, for example, of the Eurobond coming into the country, but then public didn't have a discourse and discussions as to which areas of application of those. So you end up with a situation where there's a general feeling that the debt that is being contracted may not be optimally applied, to the effect that it's contributing to the growth of the economy, thereby generating the necessary revenue to be able to pay back those particular debts. So would like to see, I think, provisions where, as far as public statement is concerned, I think there is disclosure as to which projects are intended to be financed via the debt that is proposed to be contracted. The second one, Madam Moderator, is on the issue of accountability, especially by duty bearers. By here, I'm referring to people that are in charge with managing public finances. These are controlling officers, ministers, and just other prominent influential persons. There's been a discussion and a push, particularly in Zambia, from the non-governmental organizations and a number of interest groups that we need to see, legislation around asset declaration being provided for. This enables that it's easier to track individuals that are charged with the responsibility of administering these finances to avoid them misusing, the offices that they are occupying. I don't know whether these provisions will be granular for the proposed model law and maybe can be left out for the individual jurisdictions, but it would be interesting to see if this is something that can be considered. I submit, Madam Moderator.
Thank you very much, Victor and Leah, Team Zambia, for your excellent input. And just before we revisit the floor, can we have some remarks from Zimbabwe? Zimbabwe, Team Zimbabwe, Zimbabwe delegation, if you're in the house. Okay, allow me to just revisit very, very briefly. Without without repeating too much or causing any injustice whatsoever. I don't intend to do that. But you'll allow me to just revisit some of the key points that are really coming out insofar as what opportunities do we have, or does the PFM model law have to be proactive, because there are instances where deterrence is key in preventing some of these things even before they happen. Key issues on debt management, and even an important one, public participation, because the duty bearers are taking different responsibilities, negotiating on behalf of the country, and of course, by extension, the citizens. To what extent can we capture issues of participation and disclosure, and of course, a lot of intent to prevent vulnerability when it comes to procurement, the public procurement laws. To what extent can we support coverage for that? Of course, the excellent input on the ongoing UN project. I think it has also been posted on the chat. We really look forward to receiving this, and please feel free to furnish the Secretariat with these details, because they can be important even as we move forward with these consultations. The advances, the typologies that are already provided by FIUs, and bringing in a very key point, the channels that could be maximized between the political wing and the FIUs in terms of exchange of information and conversations, and what we could do about that. So let me pause there. I think there's also a very important point before I forget, on involvement or inclusion and engagement of this decentralized public accounts committees, because they do exist. We know there is a wave of decentralization and other decisions that are made subnationally. How do we capture that? So at this stage, please allow me to hand the floor to Dr. Greenberg. Dr. Greenberg, take it away from there, and let's, try to respond to some of these issues as we continue in conversation. Dr. Greenberg.
Thank you, Madam Facilitator. I have little to add to your comments in response to the points being made by distinguished delegates, and I note in particular that the learned rapporteur will have taken a careful note of the submission of each distinguished delegate so that we can follow up and consider, and the details placed in relation to the Zambia project on illicit financial flows in the chat bar is something that we will take away and give particular attention to. I am very grateful to the support from the distinguished delegate from Mauritius in relation to, in particular, the cryptocurrency regulations and the comments in relation to emergency procurement. I would say to to those comments as follows. In my initial presentation, I mentioned that flexibility has to be within an envelope of oversight and containment. And the difficulties in relation to emergency procurement are inevitably going to be encountered in emergency situations. Nothing is served by preventing necessary flexibility to react effectively to events on the ground. What matters is that the oversight mechanism and accountability mechanism remains in place so that once the emergency conditions cease to exist, people know that they will still be held to account and required to be transparent as to what happened and why it happened when the standard procurement regime was varied. With that in mind, any comments that the distinguished delegate from Mauritius may have as to why particular aspects of procurement policy have been suboptimal in his experience in an emergency situation may enable us to enhance the references to emergency disapplication in the procurement part, and I will look forward to scrutinizing anything he is able to provide with particular attention. In response to the comments from the distinguished delegate from Tanzania, I very much agree with the point made, which was echoed by distinguished delegates from Zambia. I very much agree that we have to have a balance between prevention and cure, so to speak, between reaction and proaction. But it isn't always easy to provide what I would call effective prevention if people aren't aware that there is also a possibility of effective post-active enforcement. So I think these are not alternatives. These go together, and I don't think any of the distinguished delegates suggested that they are alternatives. We've tried to provide a balance. We have new offences at the back, and the prevention mechanisms are primarily about publicity and system, particularly in relation to the parliamentary oversight, the budget and the accounting mechanisms parts of the model law. Any gaps in those that distinguished delegates could by being filled, could enhance the pro-action part of the bill, would be enormously grateful. I would be enormously grateful to have details suggested of how those gaps might be filled and what they are. And I very much take the point at a general level, we must be providing for pro-action as well as reaction. If I may say, with great respect to the first distinguished delegate from Tanzania, from the first distinguished delegate from Zambia, if I may say respectfully, I believe that the resource accounting mechanisms already take account of assets in government custody following state forfeiture, and I would respectfully direct her attention to the provisions about resource accounting and whole of government accounting in the accountancy part. But having said that, I, of course, if she still feels that there is specific provision that should be made about the management of assets in custody post-forfeiture, then I would be enormously grateful for any suggestions she has as to specific details that might be expounded. The points made about the duties of officers by the second distinguished delegate who spoke from Zambia are very much taken, and again I will scrutinize when I see the learned rapporteur's record of those comments. I hope I have dealt with, in addition to what you, Madam Moderator, said in your responses to those remarks, I hope together we have covered all the observations made by distinguished delegates, for which I am very grateful.
Thank you very much. Thank you very much, Dr. Greenberg. We request our distinguished delegates to mute. Kindly let us mute when we are making interventions. Thank you very much. And I think at this juncture, we would like to check if there is any emerging observation that has come up, any further inspiration following the various comments that have been made by the different delegations. I think we have one more chance to open that up. If not, allow me to sincerely thank every single delegate who is in attendance today for actively participating in the plenary session, for making very incisive observations, comments, and even recommendations. And as Dr. Greenberg has already said, please let us have these in writing, because that way you enable the legal drafter and the technical team at large to really consider and craft for the inclusion of these key observations that you have already made. At this point, I would like to hand the session back to the Secretariat and to invite the Secretary General to make her observations from the conversation that has gone ahead, and to support the closure so that we can adjourn the session. Over to you, Madam SG.
Thank you very much, Ms. Caroline. And let me thank our distinguished participants for participating in this forum. Your comments are quite welcome. The normative framework that we are looking at today will greatly benefit from your comments. That would go a long way in terms of the technical working group borrowing from and looking at what is it that can be integrated into this particular process. With the necessary leadership that will come from the technical teams that you also belong to, the political leadership, this model law will be progressive for our parliaments, will be progressive for the citizens of SADC, and therefore will go a long way in demonstrating the beauty of such normative frameworks where they are domesticated, where they would make huge differences in terms of ensuring that we are robust in our approaches towards good governance. I wish to thank you for your support on this endeavor, and we look forward from getting more comments from yourselves that will further assist the technical working group and Dr. Greenberg to make sure that the complexities that we experience at national levels, the technical issues that require national legislative action are indeed processed where possible. I thank you for your attendance, and thank you, Madam Moderator, for a job well done.
Thank you very much. A warm applause to everyone in this session, thanking you for your time. It is now 38 minutes past noon in the SADC time zone, and we wish to adjourn the meeting. ICT team, I